federal appeals court on Monday overturned the conviction of a man in the killing of 6-year-old Etan Patz in 1979, a crime that alarmed parents across the country and changed the experience of childhood for generations. The man, Pedro Hernandez, had been convicted of murder in 2017 after he confessed to luring Etan into a basement as the child walked to his school bus stop alone in SoHo and attacking him. The court on Monday ordered Mr. Hernandez's release unless the state gave him a new trial within a, quote, reasonable period, a timeline to be determined by a federal judge. But it will be up to the Manhattan District Attorney Alvin L. Bragg whether to pursue a new trial in a case originally brought by his predecessor Cyrus R. Vance Jr. A spokeswoman for the Manhattan District Attorney's Office, Emily Tuttle, said the office is reviewing the decision. The fate of Etan decades ago mesmerized not just New York, but the nation, helping to usher in an era of parental fear in which children who formerly had been left to their own devices were watched closely for fear of abduction. Pictures of the boy became ubiquitous on milk cartons and posters. But it would be decades before Mr. Hernandez, a former bodega clerk, was arrested in 2012 and charged by the Manhattan District Attorney's Office with second-degree murder and first-degree kidnapping. Mr. Hernandez's first trial in 2015 ended in a hung jury. In 2017, a Manhattan jury convicted Mr. Hernandez on the 9th day of deliberations, after which the jury foreman said deliberations were difficult. Etan's body has never been found, and no scientific evidence linked Mr. Hernandez to the crime. Mr. Hernandez's lawyers had argued in the appeal that the trial court's instructions to the jury were improper and prejudiced the verdict. We conclude that the state trial court contradicted clearly established federal law and that this error was not harmless. A 3-judge panel for the U.S. Court of Appeals for the Second Circuit held in a ruling on Monday. One of Mr. Hernandez's trial lawyers, Harvey Fishbein, said that his team has always maintained that the confession was false. The 51-page ruling issued on Monday reads that an innocent man was convicted, he said. For more than 13 years, Pedro Hernandez has been in prison for a crime he did not commit, and based on a conviction that the Second Circuit has now made clear was obtained in clear violation of the law, Mr. Hernandez's trial and appeals lawyers said in a statement. They called on Mr. Bragg to drop what they called misguided charges and find the boy's true killer. Efforts to reach Stanley Patz, Etan's father, were not immediately successful. Mr. Hernandez was living in New Jersey when a relative told authorities that he suspected him of killing Etan. Prosecutors said that Mr. Hernandez had a history of sexually abusing a family member, drug use, and domestic violence. Mr. Hernandez had confessed to the crime after his arrest, but later recanted. After he confessed, police administered his Miranda warnings and, quote, had Hernandez repeat his confession on tape, according to court filings. His lawyer at the time, Mr. Fishbein, argued that the confession was false and the product of psychotic hallucinations and delusions. Mr. Hernandez had a low intelligence quotient, his lawyers also argued. During deliberations in 2017, the jury focused on his confession, with the members sending 3 notes about it to the judge overseeing the trial, Justice Maxwell Wiley of State Supreme Court in Manhattan. In a 3rd note, jurors asked the judge whether, if they found that Mr. Hernandez's confession before he was read his rights was not voluntary, they should then disregard his later recorded confession. The trial court instructed the jury, without further explanation, that the answer is no. The federal judges wrote in their ruling on Monday. The jurors returned to deliberations and convicted Mr. Hernandez 7 days later. After the conviction, Mr. Hernandez's lawyers filed appeals at state appeals courts before filing a federal petition for habeas relief, which helps ensure that people are not detained without valid legal grounds. On Monday, the judges ruled that the instructions given to the jurors would have unquestionably impacted deliberations. Under the extraordinary circumstances of this case, we believe that no fair-minded jurist would conclude that the state has proved harmlessness beyond a reasonable doubt, they wrote. Richard D. Emery, a founding partner of Emery, Shelley, Brinkerhoff, Abadi, Ward, and Maisel LLP, said that it was almost impossible to win relief from a federal court based on a state court proceeding, as Mr. Hernandez's lawyers did. He noted that the standard was whether the state court had any reasonable basis for its finding, whether right or wrong, This is rare among rare things, he said.
How do you know when this is done?